Good morning, everyone, and thank you very much for the opportunity to participate here today in this discussion on gender equality and specifically this morning on the Constitution and the law in relation to the family. The questions that have been posed to you for discussion and that I'm going to centre on really look at what our constitutional provisions are on the family and how those have impacted on how we regulate and support different kinds of family units in Ireland. The family itself is protected in the Constitution, and you've all been given the text of Article 41, which is this key provision on the family unit. It describes the family as the natural, primary and fundamental unit group of society. And then goes on to talk about the family as a moral institution with inalienable and imprescriptible rights. Now that's quite significant because just looking at the language there, you see that there's this idea of the family unit itself as being antecedent, as being superior to all positive law. So it has this kind of enshrined position within the Constitution. And for many decades, that language and that idea of the family unit is kind of sealed, as protected, as having a certain priority within society and within law. There was concern that that inhibited, that it hindered how we protected those within the family unit. Children, for example, who might be at risk of exploitation or abuse or neglect, situations of domestic violence within the family unit. Could the state intervene? Were there restrictions? What were those? Was this somehow challenging or undermining this position of the family unit? And it took quite some time to get to the situation where we began to recognise that the family is made up of many different units, including children who may be at serious risk, and that the state has an obligation to ensure protection, to ensure equal treatment, to ensure that children within family units or others within family units are also provided with protection. Now, this idea of protecting the family as a fundamental unit is not unique to Ireland or the Irish Constitution. Indeed, if we look at the Universal Declaration of Human Rights, adopted in 1948 in the aftermath of World War II, we see also this reference to the idea of the family as a fundamental group unit in society, entitled to protection by society and the state. So it is something we see in many parts of the world in many legal documents. But it leaves open the question of what kind of family, which families are given protection, how is the family to be defined, what are the limits, what are the priorities, what do we mean when we talk about the family, whether in the Constitution or in legislation or policy measures. And I guess one of the questions that you'll be reflecting on this morning is how much of this should be in the Constitution and how much should we leave to legislation and policy. So, of course, there are many different types of families, and Linda has already raised the questions around the changing nature of family units in Irish society and questions around who comes within the ambit of the family. What about joined or extended families? What about grandparents, cousins? What about dependent others, maybe nephews, nieces, others who end up in a situation of dependency that we might care for? How many of those fit into the family unit that is protected by the Constitution or in legislation? And we know that Ireland has become a much more diverse society. We now recognise and protect different kinds of sexualities and different kinds of relationships. And we're also more diverse in terms of increasing inward migration over the last 2 decades, which again is a significant change in Irish society. Now, in the Constitution itself, the family is not defined. But what we do have in Article 41.3, one is this specific reference to marriage. So the state has committed itself to guarding with special care the institution of marriage, upon which the family is founded. So this is provided for in the Constitution, and the state is given this obligation to protect the institution of marriage against attack. So it's very significant, very strong language here. It's quite defensive in terms of what it's talking about that the state must do in terms of protecting this institution. And that has given rise to much discussion, to case law, to litigation, to questions around policy. When can you intervene in the family? When can you not? What kinds of families are protected? And one of the landmark cases, quite a sad case going back to the 1960s, Nicolau and Bord Octola. Nicolau was a Cypriot national in London. He had a relationship with Miss Donnelly, who was a young woman from Galway who travelled to London, was working in his cafe, and she became pregnant. She decided to give her child up for adoption and to return to Ireland, and was in a mother and baby home. He didn't know initially about the pregnancy and only found out later when she returned to England, when they did briefly resume their relationship, that she was giving the child up for adoption. And this was without his consent. So he took legal proceedings to try to stop this, to prevent the adoption going ahead without his consent. He wanted to be given the position of guardian of care, to be recognised as the father of the child, and to not have his child going through for adoption. And the proceedings went all the way to the Supreme Court, and the court there was quite clear that as an unmarried father, he didn't have constitutional protection. Those rights that he was claiming couldn't prevent the adoption going ahead without his consent. And the court made a number of important statements that are still relevant today. Although we've had much constitutional change, much legislative change, these statements remain relevant. That the family that was protected in the Constitution is the family founded on marriage. And to give equal protection to an extramarital union, to a relationship that wasn't based on marriage, would not be giving effect to the pledge that is imposed on the state to guard with special care the institution of marriage. So you see the impact of that language on these proceedings and on his position as an unmarried father. Now, since then, there has been significant change. We had litigation to the European Court of Human Rights, where the European Court of Human Rights said that not protecting an unmarried father's right to family life was in violation of the European Convention on Human Rights. We've had legislation abolishing what was known as the status of legitimacy, the discrimination against children born outside of marriage. And of course, we've had a referendum protecting the rights of the child, the best interests of the child, and on marriage equality. So we have had significant change since then, but the Nicolau judgment remains relevant today, and I'll come back to that. So looking at some of those changes, marriage equality, already mentioned, the Constitution changed by referendum to allow for recognition of same-sex marriage. Marriage may be contracted in accordance with the law by two persons without distinction as to their sex. So that's a hugely significant change, and it was also hugely significant that it came about by referendum, demonstrating the popular will in favour of this change and recognition of different kinds of relationships. But it's still based on marriage. So again, that's the important point to note. And to give effect to the referendum and to the vote, we have had the Child and Family Relationships Act, adopted in 2015, a very significant, huge piece of legislation making all kinds of changes with regard to family relationships. It's still not fully enacted into law, so not all parts of this legislation, although it was adopted in 2015, it's been implemented progressively and incrementally over time. So again, that raises the question of how useful legislation is in terms of giving effect, responding to changing societies and relationships, and using legislation rather than the Constitution to regulate and define families and different kinds of relationships. So the Child and Family Relationships Act gives effect to the reforms from the constitutional referendum itself and makes significant changes, in particular around guardianship and custody of children. And also, again, the specific commitment to recognising the child's best interests in custody and guardianship proceedings. So that's all being implemented over time. The most recent orders that were just signed were in November 2019, and those won't come into effect until May 2020. And those more recent additional orders starting these pieces of the legislation relate primarily to donor-assisted human reproduction, and again to regulation of the relationships and the family units, the rights of the child's right to know their identity. So all of those kinds of relationships are now being regulated through legislation. There is still, however, gaps that remain to be fixed in terms of our legal frameworks. And a very significant case is the McD versus L&M. And this is a case that went all the way to the Supreme Court, and it raised the question of surrogacy arrangements, the position of a sperm donor, and the relationship rights that come from this kind of situation. And here in the relationship arose a man who had been friendly with a lesbian couple, agreed to assist them in conceiving a child, donated sperm, and originally the discussion had been that he wouldn't be directly involved in the upbringing of the child. But that changed after the child was born, and also their friendship broke down. The couple had decided to move, to leave the country, and he brought legal proceedings to prevent that and also to try to claim guardianship and access to the child that was born. And in the High Court discussion, there was significant discussion around the European Convention on Human Rights and the idea of a de facto family, and recognising and protecting private and family life and also best interests of the child. The Supreme Court, however, took a different view and decided that the best interests of the child meant that there should be access given to the child on the part of the father, who was the sperm donor, and that the High Court should work out the details of this. But this was, in their view, in the best interests of the child. They also said that the European Convention on Human Rights is subservient to the Constitution. But importantly, in terms of our constitutional position, the court was quite clear that there was no legal institution in Irish law of a de facto family. This was simply not something that was recognised in Irish law in the Constitution itself. So this idea of trying to recognise different kinds of de facto families or units, they said was not something that was recognised in the Constitution. So again, that leaves a lot unclear here. We can look to the best interests of the child. We can look to other parts of the Constitution on personal rights, on the rights of the child, Article 42, which was inserted following referendum, Article 42A. But the Article 41, which specifically relates to the family, remains tied to this idea of marriage. And again, this was reiterated by the Supreme Court in a 2018 judgment, which was a case that involved a lot of questions around immigration. But here again, Chief Justice Clarke made very clear statements that there was consistent case law on Article 41, stretching back decades, so going right back to Nicolau, which had been reaffirmed that an unmarried family with children or without children was not a family unit within the meaning of Article 41. So again, it's important to remember that that does not mean that family relationships outside of marriage have no constitutional protection, or that children in those relationships have no constitutional protection. They do, under other provisions of the Constitution. And as I said, that might relate to personal rights or the rights of the child. But Article 41, which is the specific provision on the family, is limited. So again, this is a very clear statement from the Supreme Court, just saying that we have this long history of case law, this is how it is, it stretches back decades, we've had a lot of change, societal, constitutional, legislative change, but the family that is protected in Article 41 is the family based on marriage. Now again, this was a case that involved a lot of immigration questions, and I think it's also important to reflect on the changing nature of Irish society and what can happen, for example, in the context of deportation proceedings. And we have had case law recognising that in the context of deportation, a child's best interests must be considered. But one of the very significant judgments going back to 2003, a case Lobe and Ossayende, there you had a split Supreme Court that was looking at this language on the family, the inalienable and imprescriptible rights. The two dissenting judges, Judge Catherine McGuinness and Judge Niall Fennelly, they specifically said, well, that the children in those cases were Irish citizens and therefore should not be deported, and also pointed to this protection of the family unit. The majority judgment said the family unit was protected in the Constitution, but the protections were not absolute. They were subject to the common good, and the common good was determined by the Supreme Court to be one that required the state being able to deport the family, including in practice the children who were citizen children. So the protections are not absolute. That means we can intervene in the family to provide protection, and we can also, in that context, it was permissible to remove the family from the state. Okay, I'm going to move on now to look at this specific provision, Article 41.2, women in the home. And this is something that was discussed previously by the Convention on the Constitution. It's an unusual provision. It specifically relates to women's life within the home, that a woman by her life within the home gives to the state a support without which the common good cannot be achieved. Now, even at the time of putting this provision into the Constitution in 1937, it was highly controversial. Many women, as you know, participated in the struggle for independence, were highly involved and active in political life, and objected very strongly to this provision. It was seen as positioning women within the home, but not recognising all of the other facets of women's lives. It's also very gender specific, and there were objections that it was conflating womanhood and motherhood, that all mixed in together, but also that it seemed to be fixing women's lives within the home. Now, a different interpretation of that is one that was given by Justice Denham, as she then was in the Sinnott case. This was a case brought by Jamie Sinnott, a young man with severe autism, and his mother, Cathy Sinnott. They were arguing in relation to the education rights and supports to be given to Jamie beyond the age of 18, but Cathy Sinnott was also arguing that her rights as a carer, a full-time carer, and she was drawing on Article 41.2, should be given more support and recognition by the state. And Justice Denham said that Article 41.2 was about recognising the significant role played by wives and mothers in the home, and that it didn't exclude women and mothers from other roles and activities. It could be interpreted from a feminist ethic of care perspective, recognising the traditional role historically that women have played in terms of caring relationships in the home for family members, extended family members, dependent others. But the majority, Justice Denham was in a minority, she was a dissenting judgment, giving a dissenting judgment here. The majority judgment said, and Chief Justice Keane at the time said, that Jamie and Cathy's position evoked compassion, but it didn't give rise to legal rights. And there's been a whole series of cases in which women have tried to rely on Article 41.2 to give effect to legal rights in relation to the family home or property, for example, and they have failed. So it's been interpreted as a broad kind of symbolic reference, but not as giving rise to legal rights to support the role of carers, and specifically women as carers in the home. So it hasn't been given that kind of recognition in law. It's been widely criticised by UN bodies. Here, the UN Committee on Discrimination Against Women in 2017 criticised Ireland because of the traditional stereotypes that were perpetuated by Article 41.2, and urged the committee to remove this, urged Ireland to remove this stereotypical language. The Convention on the Constitution in 2013, as the chairperson noted earlier, voted very overwhelmingly to make this provision gender neutral, to retain a reference to the role of carers, but to make it gender neutral. So that was very significant. But most of the debate, and I participated in it at the time, was around whether or not there should be a specific obligation included in the Constitution placed on the state to support the role of carers. So trying to give more teeth, if you like, to Article 41.2. And there were different votes, different percentages here. It's a bit like the outcome of our recent election. But the most number, 35%, voted in favour of putting into the Constitution a requirement that the state provided a reasonable level of support for carers. So imposing a positive obligation on the state to provide support, to allocate resources. And that's what most of the discussion was around at that time. The Irish Human Rights and Equality Commission has produced a policy paper saying, again, Article 41.2 should be gender neutral, that family life should be understood as encompassing a wide range of family relationships, including families outside of the home, members outside of the home, and Article 41.2 should be amended to recognise and support care work. And just to conclude, following on from the previous Convention on the Constitution, a task force was set up that looked at 3 different options. One was replace the text of Article 41.2, make it gender neutral, refer to caring for others, but only within the home. So not looking at care roles outside of the home, for example, where somebody may be in a residential institution. Option 2 was just to keep a very general reference in Article 41.2 and then to put into the directive principles of the Constitution, which are in Article 45, a reference to ensuring support. The significance of that is that Article 45 is not enforceable in the courts. They are called the directive principles. They're not enforceable in the courts. They can be referred to, but they can't give rise to legal rights. So it's quite different from what the Convention on the Constitution had preferred in 2013. And the final option to conclude was simply to delete Article 41.2 in its entirety and to leave that. Okay, thank you very much.